Hi, welcome to Lesson 5. This is disciplinary actions from the board. One of the most important aspects of dealing with the Board of Massage, especially in terms of your renewal. We've talked about how the board can take action against you. Usually there would be some kind of investigation, and you would probably have some paperwork that would come out from the board. Generally, it is a letter sent certified mail. Sometimes you'll get some notification by email beginning a process. Many therapists use their email to communicate with the Board of Massage. Very beneficial, as we've talked about. And when we think about disciplinary action, there's a variety of things that we want to pay attention to. There's some pieces of the law that I would like to review with you. In the handout, there are extensive notes regarding kinds of discipline and common discipline. So I want to kind of roll through those a little bit, remind you about fines and the potential for revocation, and then also to think about what to do in case of needing to file a report. So I'm going to do a little screen share just to remind you, and this will be part of that PowerPoint. One of the things that I think is so important as we're thinking about the board is made up of 7 members, as you well know. And many times as the board members come onto the board, one of the roles that they play is that they have a role on the probable cause committee. That would be a committee where information from the Attorney General's office would come in, and they would review a case to determine if they actually could gain a conviction if the investigative process continued on and the person was found guilty of whatever disciplinary action. There are times when the board does what's called an emergency suspension order. There are a variety of cases where people have received their license fraudulently and through fraudulent testing or fraudulent documentation. There is a school in the state of Florida called the Florida College of Natural Health, which had many records falsified to help people receive licensure in the state of Florida. California, New Jersey, a variety of states have problems with massage therapy schools issuing diplomas, helping people finish testing, and then having falsified documents. So there were, in 2013 through 2015, there were probably 200 to 300 emergency suspension orders that have been acted on. Some of those people have lost their license. Others have rescinded their license and voluntarily relinquished it. One of the other things that you might happen is that you could get a fine. Lots and lots of times somebody comes up in front of the board and they have not done their continuing education hours, or they were cited for practicing in an establishment without a license, and through the investigative process they got a piece of paper, or actually it's a variety of information. Part of that is the investigative process, but also some information with an outline of the charges, and gives the person the opportunity to dispute the charges or agree to the charges and sign a stipulation. Sometimes in that stipulation there would be a fine and maybe a letter of reprimand or probation. So this is the main action of the Board of Massage. This is the piece when I was the board chair that we were always in very close contact with the board in terms of emergency suspension orders, signing documents for fines and probations, and even in the time that I was the board, we made revocations on a fairly regular basis. The next slide here, just reminding you of a couple of things. There's a graph here. You'll notice that Southeast Florida has the highest numbers. That's the yellow, whereas North Florida has lower numbers. And kind of what we're talking about is cases, the number of cases, where they began, where they originated. Central Florida tends to be a very big hotbed of sexual activity or unlicensed activity. There have been quite a number of insurance fraud cases. Each part of the state has its unique characteristics. I would say to you that Miami-Dade, Broward, even Palm Beach County have a significant number of people who are operating unlicensed activity. Sometimes they are working in places that are providing insurance fraud, pain management clinics. Many places like that begin to have problems with Medicare and Medicaid. So the biggest one that I would say is mostly unlicensed activity and repeated or gross malpractice. So I'm switching the slide here to just show you in the statute, in the disciplinary guidelines, disciplinary guideline letter H. And many, many times when I talk about the scope of the practice, and we'll talk about that in a little bit, we come back to this particular statutory language to determine if I can find a case for this person, maybe have a disciplinary action taken against them. So as you see this, gross or repeated malpractice, or the failure to practice massage with that level of care, skill, and treatment, which is recognized by a reasonably prudent massage therapist as being acceptable under similar conditions and circumstances. So to me, I highlighted the words, the level of care, skill, and treatment, which is recognized by a reasonably prudent massage therapist. And depending on the maturity of the therapist, I've been a therapist almost 27 years. There are therapists out there who've been licensed 6, 8, 10 years. If we were to do some kind of expert witness work, and we were looking at whether somebody was failing to practice with a level of care, skill, and treatment, or gross or repeated malpractice, we would use these words, and we would use someone who actually was licensed in a similar time frame, had similar skills and similar background. So I could not judge someone from a 6-year therapy or 10-year therapy. I would be more of an expert witness for someone who was even more mature therapist. The next slide, practicing or offering to practice beyond the scope permitted by law. And this is a very clear reference to competency and not competent to perform. So this could also be another situation where we would use an expert witness, and we would look at the person's training, we would look at their background, we would look at their experience. And many, many times when people work in a situation like a physical therapy location or a chiropractic office, many, many times people are asked to do things that they have no business doing. Sometimes this is ultrasound machine, some of this electric stimulation, iontophoresis. There's lots and lots of things that people are directed to do. Currently in this world, there are people who are using lasers, cold laser treatments, some kind of thermography, variety of different implements that someone may actually use that they don't have actual training or skill to do, but they have been directed by someone else to do it. So that would be a disciplinary guideline. Earlier I was talking a little bit about the scope of the practice, and so I'm going to stop screen sharing here and just kind of remind you, scope of the practice is really such a variable thing for each of us. The basic guidelines for massage practice come from the definitions of massage. Many, many times when I talk to people, they have skills from many other backgrounds, skill, training in nursing, EMT, military training, cosmetology. Many, many people come to massage as a second career, so they may have experience and knowledge that really broadened their ability to practice. Some people come in as fitness trainers, some come in as athletic trainers. It's very difficult until we look at a case-by-case basis what the actual scope of a practice for everyone is. We do have the basic outline in the definition of massage. Massage means the manipulation of the soft tissues of the human body with the hand, foot, arm, or elbow, whether or not is aided by hydrotherapy, including colonic irrigation, any thermal therapies, any electrical or mechanical device, or the application to the human body of a chemical or herbal preparation. So that's a pretty big basket. And many times when I'm talking to someone and they say, well, I'm a cosmetologist or an aesthetics person, I would say that they have a very wonderful overlap in our practice. There are people who do facials, people who take care of people who have cosmetic surgeries, and their skills to touch people and to help them not only in a facial beauty way, but also in a manual therapies way is a tremendous opportunity for people. The other thing is I would just use a good example as a nurse. The history of nursing, actually, one of the things that the nurses did in the hospital wards was to massage people and help them go to sleep. Even back when I was an EMT in the late 1970s, I was a volunteer in the hospital, and people would go around, nurses, they actually had the time and the ability to do this, and they would give treatment to people and help them fall asleep. It's one of the wonderful outcomes of massage therapy. So scope of practice is a fairly broad topic to talk about. There's lots of hypotheticals that can happen. And for me, what I prefer to do is to actually talk to the individual person and find out, well, what is your actual training? What is your background? How is it that you began to think that you could do this stretching protocol or vitamin nutrition protocol, or in the case of some kind of remedial massage, working with athletes, something like that, and telling them that they have a particular injury. So when we think about discipline, there are big issues in terms of the board of massage and how they actually operate in terms of disciplinary issues, investigative issues, issuing initial licenses. I think what I'll do is I'll screen share for a second here and remind you that in the booklet we have a variety of situations where I think if you read the phrasing and made some just cursory look of this, you would see that attempting to procure a license to practice by bribery or fraudulent misrepresentation would be grounds for discipline. Or in the case of letter C, being found or convicted or found guilty regardless of adjudication of a crime in any jurisdiction. So there's a variety of very clearly delineated disciplinary issues. The newest disciplinary issue that I wanted you to see, and I put this in red in preparation for this, when we had changes in the establishment rules, we also had some changes in the disciplinary guidelines. And so we have letter E, advertising to induce or attempt to induce or engage or attempt to engage the client in unlawful sexual misconduct. And of course, that's referenced in another section of the law. I think it's pretty straightforward for most of you who are professional massage therapists that having sex with your clients is not only unprofessional, but also grounds for discipline. This is a very sensualized and sexualized world, and very many times people are confused about the non-sexual nature of massage therapy. This is an attempt by the legislature and the Board of Massage to be sure that any advertising that is done, whether it's on Craigslist or radio ads or Facebook, that we don't have sexy pictures, that we don't hint at extra services, and so it's just a few more teeth for the probable cause committees to work with. One of the most important areas that I wanted to come to is in terms of letter O. Many people ask about this establishment, and I just wanted you to see it here. You can practice at the home of a client. You can practice at the office of a client. You can practice at a sports event, a convention, or a trade show. And as we look on the handout, there are a variety of pieces in the commentary that I would like for you to be aware of. Chapter 120, the administrative code, has rights and obligations for you if you had some kind of disciplinary case created against you. There is a way for you to actually do some kind of complaint yourself. And then in my Dropbox, we also have some articles and information in my Just Ask Pete section. I think it'd be very helpful for some of you if you need a little bit of reading to take a look at that. I think you will find it interesting. These are from the rules, 64B7-30, and there are some additional rules to the statutory requirements or disciplinary areas. And one of the things that's fairly important for us to realize, number 2 says violating the confidentiality of information or knowledge concerning a client. That wasn't in the statutory rules. It is in Chapter 456, which is the healthcare practice, but the board just felt it was very important to be sure that confidentiality was covered as a grounds for discipline. You'll notice in 4 and 5, we go round and around with this in terms of draping and the expected draping techniques. I think it's very clear, and so I'm just going to state it right here, that the standard operating expectation for the board is that clients are draped, that their buttocks and genitalia are covered. The breasts of female clients are covered unless the female client gives specific informed consent. Informed consent is a very specific healthcare term, and I want all of us to really consider all aspects of informed consent. When you're sitting in a chair, both of you in the clinic room, and you both have your clothes on, and a person says, "I'd like for you to work on me, and these are the areas," and then you step out of the room. Client gets onto the massage table, doesn't have their clothes on and are under the table, the power differential has changed. And so I would think it would be very important for you that if you're going to change the agreement or begin to work in an area that wasn't agreed upon, that you continuously obtain informed consent, so that your client feels like they are well informed. And the most important aspect about informed consent is really that it can be withdrawn at any time. And I think this is an issue for therapists, is they maybe begin a session and have informed consent for certain things. Hey, well, I really want you to work on my glutes and my back and my hamstrings, and these are the areas I really want to concentrate on. And then the therapist themselves takes it upon themselves to do other types of work. Maybe they're flipping them over and working in areas that the client isn't quite as comfortable with. It might be good to check in. Is it okay if I continue in this particular area? And the words, is it okay, or would you like me to continue in this area, or would you like me to work in this area, are very clear questions that someone can say yes or no to. I'd say there's a section in the disciplinary guidelines about the fees and what are the possible fines and fees, and could you have a reprimand. So I just would say to you, over the life of the times that I've been watching the board, there have been $10,000 fines, there have been $5,000 fines, there have been $1,000 fines. They will look at the disciplinary guidelines. If this is a first offense and the disciplinary guidelines say reprimand and a fine of $500, that's pretty much what the board will follow. If we have many charges, multiple counts in a particular case, there might be multiple fines and court costs also affected. So then there is something called a citation. And in the disciplinary section, a citation is very much like a ticket. The inspector is usually the person who finds this violation. You'll remember from the last section that our establishments get inspected every year, usually around the same time that your original inspection was. And if there are problems with your display of your license, or you're not holding your insurance, or it's not up to date, fire extinguisher, any number of things can be citations, and that's a way to reduce the need to do an investigation. Usually the therapist is well aware of the situation. They sign a stipulation and pay a fine, and many times receive a reprimand. Earlier I talked about the probable cause panel, and I think that if you came away with the fact that if you were to volunteer on the board, one of your jobs could be to review cases and to determine if a conviction could be had or implemented against a licensee who had some kind of disciplinary action. There is a section on advertisements that reflects some of what we talked about above. I think what I'll do is I'll stop screen sharing here for a second. And for the purposes of this class, the discipline section, it seems fairly dense for some people. To me, this is the place I'm actually looking for to be sure if someone comes to me and says, hey, this person went to another therapist and they were touched inappropriately. I would help the person take a look at the disciplinary guidelines, ask them if they felt that maybe the statute had been violated or the rules had been violated, and help them begin to maybe have a dialogue with their client. Sometimes we have to have a universal complaint form so that we can share that with the client. Many times I have encouraged people at my live classes that they have a folder with a universal complaint form. It's very easy to download from the board website. So having that form gives the client the ability to have a complaint, have the license number of the person, and to lay out the charges. Sometimes this happens on a the same person, and so other people may actually file a complaint as well. Some people in different chapters or parts of the state have a grievance committee, and they actually physically get together, 3 or 4 folks, talk about what's going on, what maybe some of the evidence is, and join together and send in a UCF together. A good example of that would be if there was someone who was advertising sexually suggestive massage. Be very clear that it would be easy for 3 or 4 people to have seen the ad, to put their names on the UCF, and kind of move on from there. All right, so if we just remind ourselves from the PowerPoint, there's so many aspects of being a massage therapist that sometimes it's hard to keep up with them. In this class, I'm hoping that it's pretty clear to you that renewal and the ability to renewal depends on your taking classes. And when we're thinking in terms of disciplinary guidelines, right, this would be one of the areas that I will be being sure that you're well acquainted with. One last piece here, delegating professional responsibilities to a person when the licensee's delegating such responsibilities knows or has a reason to know that such a person is not qualified by training. experience, or licensure. And again, we talked about this performing duties that you're not competent to perform, but this is then at the next level, which is you're a massage therapist, you're busy practice, and you have a receptionist who does a massage because you're busy and you want to have that money. Or you have a son or daughter who is wanting to become a massage therapist, and you have them practice on some of your clients, and that person either is doing it for pay, or you're accepting the money on behalf of your child. Okay. So the final piece, and we've talked about this a little bit, is there are a tremendous number of issues coming up with the fingerprinting, and over the time in the next couple of board meetings, there may be some rulemaking regarding schools and education. And if I could just make one last pitch, and I think I've done it 3 times in this video now, if you are a Florida licensee and you are concerned about your profession, and you've been licensed for over 5 years, I think it would be very beneficial for you to consider applying to the board, to applying to the governor's appointment office, and seeing if you could come on to the Board of Massage. All right. So thanks so much for watching this particular section. Review any of the materials in the handout. The PDF, of course, is available to you, and we're getting close to the end, and I wanted to be sure that you've got all your bases covered. Thank you.